Hello viewers, in this lesson we will learn about the letters of credit. Objectives: to learn about the meaning, definition and the modus operandi of letters of credit, to learn about the kinds and other aspects of letters of credit. Viewers, now we will learn about meaning. In the modern global banking practice, the letter of credit, called in short LOC, plays a very pivotal role in both national and international transactions. Letter of credit means a written undertaking from a bank to pay a beneficiary against the delivery of certain requisite documents. It is one of the very valuable services provided to the business community by the bankers. Basically, a letter of credit carries a promise by the issuing banker in favor of its customers, which is honored on a global basis by the other banks. By this instrument, a banker requires another party, who could be a trader or a banker, to grant a specified amount to a third party specified therein, and the issuing banker binds himself to pay the money paid under the letter of credit. Letter of credit is also termed as documentary credits. Operationally, a letter of credit is viewed as a method of payment less secure than payment in advance. However, from the point of view of a seller, it is more secure than documentary collections and open account. From the point of view of a buyer, it is more secure than payment in advance, but less secure than documentary collections or open account. Mostly, the letters of credit are governed by the rules promulgated by the International Chamber of Commerce, which is also termed as the Uniform Customs and Practice for Documentary Credits. The rules are available on the official website of ICC. The term letter of credit originated from the French word accreditation, which derived from the Latin term accreditivus, which means trust. Definition: in common parlance, a letter of credit is defined as a written commitment to pay by a customer's bank, called the issuing bank, to the third party's bank, called the accepting bank, or the negotiating bank, or the paying bank. The letter of credit guarantees payment of a specified sum in a specified currency, provided that the seller meets precisely defined conditions and submits the prescribed documents within a fixed time frame. These documents include a clean bill of lading or an airway bill, a commercial invoice, or a certificate of origin. To issue a letter of credit in favor of the seller or exporter, who is called the beneficiary, the buyer, called as applicant or account party or opener, either pays the specified amount along with service charges upfront to the issuing bank or negotiates a credit. A letter of credit is a negotiable instrument, and the related instruments are bill of exchange, letter of guarantee, irrevocable letter of credit, and standby letter of credit. The Forlex Financial Dictionary defines a letter of credit as a statement issued by a bank to the buyer of a good, stating that the seller will receive payment on time and in the correct amount. If the buyer fails to make payment, the bank will do so on his her behalf. The buyer presents a letter of credit to the seller, which eliminates the risk that the seller will not be paid. Letters of credit have become very common in international commerce, as distance and other factors make it difficult for sellers to establish the creditworthiness of every buyer. The Collins Dictionary of Business defines the letter of credit as a document used to effect payment for internationally traded goods, usually as part of a contract for the sale of goods, which ensures that the supplier receives prompt and guaranteed payment, while the purchaser obtains a short-term credit line. In brief, under this facility, a purchaser in country A of goods supplied by a firm in country B can arrange a letter of credit from his bank, the credit issuing bank, authorizing it to make payment to the supplier either through a branch of the bank in country B or more usually through a bank, the negotiating bank, holding the supplier's account. Under a contract of sale of goods, this will be done on the presentation to the negotiating bank of documents stipulated in the letter of credit, such as the bill of lading, insurance policy, certificate of origin, etc. In the case of certain letters of credit relating to particular transactions and customers located in heavily indebted countries, a secondary market has developed to offset political as well as commercial risk. In the Complete Real Estate Encyclopedia, written by Dennis L. Evans, the letter of credit is defined as an instrument issued by a bank or other financial institution, issuer, agreeing that it will pay money to another beneficiary on behalf of the bank's customer, account party, upon the happening of certain named events. There is usually an issuance fees of 1 to 2% of the face amount of the LOC. Modern banking regulations require the same underwriting as for a commercial loan. The LOC will set out the exact prerequisites to be met before the bank will issue payment. These usually include a particular time and place to present the original letter of credit and the exact documents that must accompany the letter. Some states still follow the old strict compliance rule, holding that any deviation from the instructions, no matter how minor, will justify the bank in refusing to pay. Others follow a substantial compliance rule so that minor typographical or syntax errors in the presenting documents will not justify non-payment. 5. Under the Uniform Customs and Practice for Documentary Credits, UCP, a letter of credit is defined as any arrangement, however named or described, whereby a bank, the issuing bank, acting at the request and in accordance with the instructions of a customer, the applicant for the credit, is to make payment to or to the order of a third party, the beneficiary, or is to pay, accept, or negotiate bills of exchange, drafts, drawn by the beneficiary, or authorizes such payments to be made, or such drafts to be paid, accepted, or negotiated by another bank against stipulated documents, provided that the terms and conditions of the credit are complied with. Modus operandi. After a contract of sale is entered into by the parties and they agree upon a letter of credit being issued as the modus of payment, The applicant requests his bank to issue a letter of credit. Then the issuing bank ascertains about the creditworthiness of the applicant and issues the letter of credit. Subsequently, the beneficiary, on the receipt of the letter of credit, will check the terms to ensure that it matches with the contract and will either arrange for shipment of the goods or demand an amendment to the letter of credit so that it would comply with the terms of the contract. The LOC is limited by time, the validity of the credit, the date of shipment, and the time of presenting the documents to the nominated bank. As per the normal practice, once the goods have been shipped, the beneficiary will present the set of requested documents to the nominated bank. The bank will check the documents, and if they are found in compliance in terms of the LOC, the bank has to honor the terms of the LOC and pay to the beneficiary the stated sum. If the documents do not comply with the terms of the LOC, they are called discrepant. Then the nominated bank will inform the beneficiary about the discrepancy and offer appropriate options depending upon the circumstances. If the discrepancies are minor, they are curable. As per the business practice, in the event the corrected documents cannot be supplied on time, they may be forwarded to the issuing bank in trust, hoping that the applicant will accept the documents. This method must be used only as a last resort because the documents forwarded in trust remove the payment security of the LOC. As an alternative method, some banks will make the offer by telex for approval or the modern electronic medium of email. This is possible where the nominated bank holds the documents but sends a message to the issuing bank to accept the discrepancies. This method is considered to be more secure than sending the documents in trust. The requisite documents in LOC. In case of issuing LOC, the various types of documents normally submitted are as follows. 1. Bills of exchange. 2. Invoice. 3. Bill of lading, airway bill, roadway receipts like the lorry receipts, railway receipts, cargo receipts. 4. License embassy documents. 5. Insurance documents. 6. Any other document as per the terms and conditions for issuing LOC, which may differ from country to country. The law that applies. In India, the law that basically applies to LOC is the Indian Contract Act 1872. Further, various legislations narrated in earlier lessons in relation to banking business also are applicable, as the LOC is one of the prime business activities of international banking. Further, the LOCs are also subject to the governance under the rules of International Chamber of Commerce, presently called UCP 600. Internationally, some countries have created special statutes regarding the LOC. As per instance, in USA, many states adopted Article 5 of Uniform Commercial Code. These statutes are enforced to work with the rules of practice, including UCP 600. As the UCP 600 is not a law, the parties to the contract must include them in their contracts as a relationship that arises out of a LOC among the different parties is contractual. Viewers, we will now learn about kinds of LOC. The LOC by practice can be divided into two kinds, namely Traveler's Letter of Credit and Letter of Commercial Credit. They are discussed hereunder. 1. Traveler's Letters of Credit. For travelers within the country or abroad, carrying huge cash is very risky. Especially in the present day, March 2017 scenario in India, there is high cash crunch in the banks due to the demonetization effected in November 2016. Further, there is a danger of losing the money or somebody stealing it. To save such a catastrophe, the banks issue travelers' letters of credit. The features are as follows. A. This LOC is issued by a bank on its own branch or correspondent bank situated within the country or abroad. If it is addressed to more than one bank, it is called a circular LOC. B. The amount of payments to be made to the holder of LOC is specified. C. The procedure for payment and the recording is stipulated. D. Along with the LOC, a letter of identification of the holder is also issued. E. The applicant for LOC has to deposit the requisite amount with the issuing bank or make such alternative arrangement as per the norms of the bank. F. The applicant, instead of depositing money with the issuing banker, may furnish a guarantee for issuing LOC. Based on such a guarantee, if the LOC is issued, it is called Guarantee Letter of Credit. The traveler's LOC are varied types. A. Circular notes. These are similar to checks but with a specified denomination printed thereon. The holder will encash these notes by rendering them to the concerned bank. The holder gets full value for which these notes are issued. B. Circular checks. These checks are issued in different colors which indicate the maximum amounts up to which these checks may be drawn. The banks send these checks to their branches and correspondent banks abroad. The foreign banks or the branches in foreign countries sell these checks to persons intending to visit the country of the issuing bank. Subsequently, they send to the issuing bank the details of the sale with the proceeds. The buyer of the circular check would receive payment from any branch, agency, or the head office of the issuing bank. After making payment of the check, the issuing banker debits the account of the banker who sold the check. C. Traveler's checks. These checks are issued for the convenience of traveling public. These checks are issued with a specified denomination printed on them. The buyer is required to sign on this check at the time of its issue and the issuing banker confirms his signature. At the time of receiving payment, the buyer has to sign again at the specified place on the traveler's checks and the two signatures must be tallied. The advantage of this system is that if the check is lost, it is very difficult for the finder to receive payment by impersonation. 2. Letters of commercial credit. Letters of commercial credit are issued in commercial transactions, wherein the issuing bank makes the payments to the beneficiary directly. In several cases, the exporters are not personally acquainted with the importers. In such cases, the exporters will have to bear high risk for payment. To avoid such a risk, the exporters ask the importers to arrange a letter of commercial credit from the importers' banks in favor of the exporters, so that as beneficiary holder of the LOC, the exporter can receive payment. The commercial letters of credit may be of different types, like the documentary letter of credit, clean letter of credit, fixed letter of credit, revolving letters of credit, revocable and irrevocable letters of credit, confirmed and unconfirmed letters of credit, with and without recourse letters of credit, transferable and non-transferable letters of credit, back-to-back letters of credit, red clause letters of credit, and like ones. These types and kinds may be adopted based on the banking practice of the particular country and the reciprocal arrangement with the counterpart banks, agents, and the persons concerned. Liability and right of the issuing banker in LOC. The liability of the issuing banker in case of LOC was stated by the Supreme Court in Tarapur and Company, Madras versus Messrs. Shavo Tracto Export, Moscow, and another. In this case, it was held that a letter of credit is independent of an unqualified contract of sale or underlying transactions. The autonomy of an irrevocable letter of credit is entitled to protection. The banker issuing an irrevocable letter of credit gives a firm undertaking to the exporter that the bill drawn in terms of the letter of credit will be honored. This commitment is subject to the fulfillment of the conditions laid down in the letter of credit itself. If, on the other hand, the exporter supply inferior goods or equipments and violates his agreement with the importer, the liability of the issuing banker remains unaffected. However, this principle is not applicable in a case where the seller commits any fraud. Once the seller is paid the LOC amount, the issuing banker gets the right to claim payment from the buyer of the goods. The buyer of goods remains liable to pay the issuing banker even if the ship carrying the goods sinks and the insurance policy is in the joint names of the buyer and the banker. Risks of LOC. The LOCs carry some risks also, and a shrewd banking practice will prevent them. The possible risks are narrated hereunder. 1. Risks out of government policy. The policy of the governments of the different countries may prohibit or restrict the performance of LOC. 2. Force majeure. The contract may be frustrated due to factors like natural disasters, armed conflicts, wars among nations and like ones. 3. Risks arising out of legal action. The performance may be stalled due to any injunction orders of a court of law. 4. Risks arising out of fraud. The payment may be obtained by committing fraud by the parties. Sometimes payment may be obtained for non-existent entity. 5. Risks arising out of several factors. Factors like social, economical, political and other financial issues may bring risks to the performance of the LOCs. In spite of all these risks in present-day banking practice of the world, LOC cannot be dispensed with. Necessary safeguards are ensured by the governments, banks, and the parties to make it more safe and useful. The students are advised to study the UCP 600 along with other Indian and foreign laws to upgrade themselves further on this topic. Well, viewers, I hope you have enjoyed this lesson. We'll meet again in the next lesson. Thank you.